Hi everyone, my name is Rachel Marks and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Chad Michaelson, a Pennsylvania construction lien law guru. Today's webinar's topic is Don't Sign a Release Until It Passes This Checklist. So without further ado, I'd like to introduce the fabulous Chad Michaelson.
Thank you very much, Rachel. That's a very nice introduction, and welcome everybody. We are going to spend a little time this morning talking about releases and waivers. The first thing I wanted to cover before we get started just are some instructions for the webinar. There is a chat box down on the right that you can use to post questions. I'll watch that and try to answer your questions at the end of the presentation. And of course, don't include anything specific in your questions. Just give me the question and we'll try to cover the topic. So let's start with sort of being on the lookout for releases and waivers. It's not just the waiver that you're asked to sign when you provide a payment application. Releases and waivers come in many forms throughout the course of a project, and there are lots of places where you should be on the lookout. The first place is at the beginning of the project. There are a lot of contracts and subcontracts that include advance waiver provisions. Now, when we talk about lien rights, Pennsylvania law does not allow an advance lien waiver by a subcontractor or a supplier. You cannot be asked to waive your lien rights before you've been paid unless the owner, or I'm sorry, the general contractor posts a payment bond. So if you see a contract that says you waive your lien rights and there is no payment bond, that waiver is not effective. But if your subcontractor or your contract says you're waiving lien rights for a subcontractor or supplier, you absolutely want to see the bond. You want to make sure that there's a bond in place and you want to have a copy of it because that's where your payment rights will be limited. The other thing to watch for in your contract is not just with respect to liens, but other waivers. So a lot of contracts will try to waive CASPA rights. CASPA is the Pennsylvania Contractor and Subcontractor Payment Act. It provides very important payment protections for contractors and subcontractors, and it is not permissible to waive that. So while if a contract says you waive your CASPA rights, it doesn't matter. You can sign it. You don't need to negotiate it because that won't be effective. There are, however, other waivers that are effective. And many subcontracts, for instance, will provide that the subcontractor waives its right to seek certain kinds of additional compensation. One very common waiver you might see is that you waive the right to seek additional compensation for loss of productivity, right? If you encounter stacking of trades or other interferences. Those waivers can be effective. Pennsylvania law provides that if the owner interferes, that can void one of those waivers, but nonetheless, you need to look for those in the contract. So, you see whether it uses the language that you waive the right to additional compensation or that you release any claims for additional compensation. Those two terms have a difference in the law, which we'll talk about later, but for practical purposes, they're one and the same, and you need to watch for those things. Second place that you need to look for evidence you need to look out for releases and waivers is with change orders. It is somewhat typical for an owner or a contractor to include in a change order release language or waiver language that says by agreeing to this change order, you waive your right to any other compensation as it relates to the change order work. Now that might be fine if it's a discrete amount of work and it's fully priced and you're fully compensated for what you're doing. But the problem can be that if you waive that right and that change order has an unknown impact on your productivity down the road, or that work causes delays to the schedule and you didn't request an extension of time in the change order, then that waiver language in your change order can be problematic. So 2 things you need to do when you see waiver language in a change order. The first is that you need to make sure it is limited to the change order work. You don't want to sign a change order that says, I waive any rights for any additional compensation for anything that happened on the project prior to signing this change order, because you might have other issues that you're not getting paid for in the change order. And number 2, you need to really think about that change order, and you need to be sure that the money and the time you've requested is all you need. So, you need to look at the language of the waiver. You need to read it and understand what it is that you're waiving. Finally, you commonly see waivers and releases in your payment applications, or they are required to be submitted with your payment applications. Here, we need to talk about the 4 types of waivers. It's really actually 2 different types, 2 sets of 2 different types. The first types of waivers that you need to look for are conditional waivers and unconditional waivers. Conditional waivers are before payment is received, and unconditional waivers are after. So it's conditional because a waiver is conditional on payment. At the top of this presentation, I said Pennsylvania law does not allow for an advance waiver of liens. It only allows for a waiver of liens to the extent you've been paid. So your conditional lien release is the one you submit with the payment application, and it says, when I receive this money from the payment application, I waive my lien rights. The unconditional lien waiver is one that you submit after you've received payment. So depending on the way the project is administered, you might need to submit a conditional lien waiver with your payment application in order to get the money. But then the next month, you might be asked to submit an unconditional lien waiver that covers everything through the prior payment application. Some owners that I work with do that, and they say, we want an unconditional waiver for everything that we've paid you on up through the prior app, and we want a conditional lien waiver for what you're requesting in this payment application. It's a little bit of belt and suspenders, but it explains, I think, the difference between conditional and unconditional. So you need to read the lien waiver they're asking you to sign. The other type of payment application, of course, there are interim waivers and final waivers, right? The interim waivers only cover the work done at the time of the waiver, so those go with your payment applications, but the final waivers are at the end of the project. Those can be conditional or unconditional as well, depending on when you submit them, but those are important because those really are going to waive any kind of open claims that you might not have resolved by the time that you get to final payment. So, so when you're looking at your interim payment applications, make sure that you're carving out any kind of pending change orders or claims or disputes for which you're still seeking payment, right? If you say that you waive all of your lien rights for all of the work that is covered on a certain, through a certain payment application, and you actually have, you think you're due additional compensation for some of that work, but you haven't received it yet, you might waive the right to seek that change order, or you might waive the right at the end of the job to say that you haven't been paid in full. So you need to sometimes on your lien waiver carve out the pending change orders, either by identifying them or just some language that says this does not include the change orders or the claims we've made to date. Now, the title of this presentation was "Don't Sign a Release," but there are different types of documents that are often presented to contractors, subcontractors, suppliers. Sometimes the waiver you're asked to sign is more than a waiver. I've seen many waivers that include a release and a waiver and an indemnity provision. And let me explain to you why those 3 are different and why you may or may not need to give all 3. So A waiver is basically giving up a legal right in advance before anything happens, right? It's saying, I waive my right to file a lien, even though you might get paid on time and you might never need to file a lien. I waive my rights under CASPA, even though maybe the owner pays you on time and you don't have any rights under CASPA. But a waiver is essentially an advance waiver of claims. A release is to extinguish existing claims. So that's where you actually have made a claim against the owner, or you have a claim and you say, you know what, this is settled. I release this claim. I will not sue you for this claim. And there's, of course, a difference between the two, especially when you have pending disputes that are unresolved. So a lot of lien waivers might start with that language that says, hey, I waive my lien rights for everything that you've paid me for. I promise I've paid my suppliers. Nobody will file a lien for the amounts that are paid through this payment application. And that might be okay. Then it'll go on to say the contractor or the subcontractor also releases all claims for any compensation for any work covered through this payment application. Well, that could be problematic. Again, that's where you have the issue with any outstanding claims that you need to be careful to carve out or to communicate with the owner to make sure that your waiver isn't construed as a waiver of those claims. Now, releases and waivers, kind of similar, slight differences from a legal perspective, but the bigger one that you need to watch out for is indemnity. Now, we all know what indemnity is. It's common in the industry, and it's something that you look out for in your contracts, and you look at what is the scope of the indemnity and what you're indemnifying for. But in this context, it's very common for owners or contractors to request not just a release and waiver of lien rights, but indemnity. Indemnity meaning that if one of your subs or one of your suppliers files a lien, that you're going to pay for the legal defense of that claim, and that if you can't get that claim to go away, that you'll bond it off or you'll pay it. So you will fully protect the owner from any damages. Now, if you're an owner, that makes sense. If you're a contractor, it might make sense to request that from a subcontractor because you do expect those people lower in the chain to pay the people who are supplying labor and materials. And if they don't, they should be responsible. But indemnity is a big responsibility, and it's qualitatively different than a release or waiver. So you need to look for those, and you need to determine whether you need to or want to give indemnity if it's asked and included within a waiver that someone puts in front of you. So what can you do when you are asked to sign a release or waiver? What must you do before you sign? And this is our sort of checklist that we teased in the title. So don't sign your waiver or your release unless it's consistent with the contract. That's where all these obligations flow from. If you have a contract that doesn't say you need to submit lien waivers with payment applications, you don't have to. Now, you might choose to do that, right? It's not a major risk for you to waive lien rights if in fact you've been paid on time and you've paid your subs and suppliers and you know that there's no risk of a lien being filed. But when a project is slow pay or when you have outstanding claims, those waivers become riskier. And if the contract doesn't say that the owner has the right to get a lien waiver before they have to pay you, then the owner doesn't have the right to demand that. And if they put one in front of you and they refuse to pay you for not signing a lien waiver, that's a violation of the Contractor and Subcontractor Payment Act. They're going to be liable for interest and penalties. So start with the contract. What does it require? The other thing to think about when you look at the contract is exactly what does it require? Does it provide a form? A lot of contracts do. A lot of owners will provide a form of a lien waiver that they want to see. They'll provide a form of an interim waiver and a form of a final waiver. And sometimes it's a different waiver for a contractor or a subcontractor, but they'll provide the form. Look at that form. right? And go back to the prior slide. Look at that form and see, does it include things like indemnity? Does it include releases? Is it a broad release of claims, or is it only related to payment? And compare that to the contract. If the contract just says you will submit a waiver, a lien waiver with your payment, then they have no right to ask you for the indemnity, and you don't need to sign it. And again, if they don't pay you for that reason, then they're violating CASPA. So if you have questions about what is required of you, you start with the contract. There is no legal requirement for a contractor to submit a written lien waiver to get paid. That is only imposed as a matter of contract. Now, if they don't include a form with the contract, use your own, right? Use a lien waiver that you are comfortable with. Work with your counsel to develop a basic lien waiver that only waives the rights for the payments you've received, that carves out any claims that might be pending on the project, and that provides you with sufficient protections. Provide that. Now, again, if the contract doesn't say the owner gets to specify the form, if it just says you have to submit a lien waiver and you submit a lien waiver, they don't get to withhold payment. So those two things go hand in hand. Look at the contract, and does the contract not only determine do you have to sign one, but then what form is it? Does it come in? So two other things, and I've already touched on these points. You need to be careful with the waivers you sign. You need to make sure they're limited to claims that have been resolved and paid. You need to be sure that they are limited to amounts to monies you have received. I typically in contracts will, when an owner asks for things like indemnity or asks for the contractor to waive lien rights, I'll add the language that will waive lien rights or will indemnify you, but only for work for which we've been paid. If the owner is a slow pay or the contractor is a slow pay and you have issues with people downstream because of that, then you shouldn't be asked to take on that risk. So look at where you are in the project, look at what the owner or the contractor is doing in terms of the timing of payment, and make sure that you're not waiving any important rights as a result of that. And know the difference between conditional and final waivers. Look, I'm not giving this from an owner's perspective, but if you're a contractor and you're worried about protecting the owner from liens or not having to indemnify the owner, then an owner or a contractor should be looking at conditional waivers for a current payment application as well as an unconditional, because that means that if I'm on payment application 3, for instance, in a job, that means that with payment application 3, not only do I get a conditional waiver that says when I pay, the lien rights will be released, but it also says when I pay that pay app, you're going to certify, again, with an unconditional lien waiver that you have actually paid your subs and suppliers all the money that I gave you in payment applications number 1 and 2. That's a good protection if you're a contractor, or frankly, if you're a subcontractor dealing with a sub-sub who's submitting multiple pay apps or whatever it might be. So, depending on your perspective, that's important. Now, that's the sort of checklist, sort of the rundown of issues, but happy to take any questions. I don't see any in the chat right now. If any pop up, I'll answer them, but for the moment, I'll just turn this back over to Rachel.
Thank you so much, Chad, for your time this morning and educating us on this important topic. You provided super helpful information as always, so we thank you for that. Right now, I do not see any questions just kidding, one just came through. And the question is, Chad, did you say it's CASPA? Please clarify. CASPA? Please clarify.
That's right. It's the Contractor and Subcontractor Payment Act, CASPA. Very important to every contractor and subcontractor. Some of the provisions are pretty straightforward. You should go read it yourself. Some of them are a little confusing, but the provisions about payment and the timing and when the owner or the contractor has the right to withhold payment, very, very important to understand.
Okay, and that is the only question that we had. However, if anyone here does think of a question after the webinar, please feel free to reach out to myself or Chad, and we will make sure to answer any questions that you may have. If you will please go to the next slide for me, Chad.
Sure. Yep.
Okay, if you guys would like to take a moment and review us on Google, we would appreciate that. And if you'd go to the next slide. Okay, so let's talk about our next webinar with Chad. The title will be Getting Paid Faster with Liens, Bonds, and Contracts, and that will be on Thursday, November 9th from 9 a.m. to 9:20 Eastern Standard Time. You can go ahead and register for free at sunraynotice.com/webinars. And if you go to the next slide. And that's all we have for you guys today. So thank you so much for joining us this morning, and I hope everyone has a sunny day. Thank you.